Ms. Milito.
Chairman Pierce and board members. I spoke yesterday, so I will just keep my remarks today brief this morning. While changes to the board's current rules on election procedures would affect businesses of all sizes, NFIB, the National Federation of Independent Business, on whom I'm appearing on behalf of this morning, is primarily concerned about the impact on the country's smallest employers. When it comes to labor issues, NFIB's constituency is very unique as compared to most businesses represented by other trade and business associations. Very few NFIB members have a dedicated human resources professional. Even fewer, if any, NFIB members have a dedicated labor relations expert or in-house counsel. And typically, all employment and labor matters are the direct responsibility of the small business owner. The proposed time frame under which elections will be held in potentially 10 to 21 days from the filing of a petition will be particularly problematic for small business owners who have few administrative employees and few, if any, in-house labor experts or in-house counsel to comply with the expedited procedures. The proposed rule does not properly balance the rights of employees, employers, and labor unions in the pre-election period. And the shortened timeframes deprive employers of their due process rights under the Act. The collective goal, I believe, of an election is to have an informed constituency. And to do so, you need to have both candidates show up and express their views. And 10 to 21 days is just not enough time for a small employer to find someone to prepare a message and deliver a message to the employees. Communication with employees is a protected right of employers, and we are very concerned that the proposed rule would prevent employers from effectively communicating with employees about the unionization process. As crafted, the proposed rule deprives employees of making an informed choice, strips small businesses of due process, and compromises employee rights. In contrast, NFIB believes the current union election process, which takes a median of 38 days, generally provides enough time for unions to make their case and, importantly, for employers to make theirs, and for employees to have the information they need to make a fully informed choice. Thank you.
Where do you get 10 to 21 days from?
The proposed, potentially. I mean, we just heard Mr. Petrusky say potentially it could be 10 days.
Okay, so if it's 10 days by virtue of stipulations of the parties,
right,
is there an injustice going on?
I believe potentially there still could be, yes. Or you have a small business owner who has agreed to a stipulation because he feels cornered in a box. He found counsel. It took him several days to find counsel, and he's not sure what to do. So he signs something because he's not sure what else. He is acting in kind of under pressure, if you will.
Okay. So currently, parties can stipulate.
Yes.
Currently,
and in most elections they are stipulated. I understand that. Yes,
right.
absolutely.
And
I would
currently,
agree. Yes.
parties can waive the time period for the Excelsior list.
Mm-hmm.
Can waive other things and have an election
mm-hmm.
in less than the 38-day period.
Right.
In 21 days, possibly.
Mm-hmm.
That can happen now.
Yes.
Do you think that is depriving an employer of an opportunity to educate its employees?
In some situations, I do think the employer is deprived of their right because, again, I think they're acting under pressure. And I think ultimately, again, as I said before, the goal is to have an informed constituency. So we want to make sure the employees are informed and hear both sides, too. So I think in some situations, you're shortchanging the employees. You're boxing the employer in a corner. Everything is condensed, accelerated, if you will. So the employees ultimately don't hear both sides.
Now, of course, we don't know what employers feel boxed into a corner to enter into a stipulation because of pressures or what have you, or which employers find it expedient to just do that because they think they can communicate effectively with their employees. We don't really have data that distinguishes between them. is it your suggestion that the proposed rule compensate for that possibility anyway? That employers may be entering into these stipulations under duress?
I think right now, the median right now of, 30 to 47 days, I think is working well. And I think that was Mr. Torres's testimony, and I agree wholeheartedly with that. I mean, I think flexibility is needed, and I'm not saying that all employers, small employers who enter into a stipulated agreement, that's not what I'm saying, are doing so under duress. I just think, accelerating it is only going to hurt small employers because they don't know what to say, so they don't say anything. I mean, they know there's a lot that they can't say. And so I think what I hear from my members is it's better just not to say anything until I find a lawyer who tells me what I can say or what I can or cannot do.
Well, but in light of that, would you suggest that parties be prohibited from entering into stipulations if it results in an election that is shorter than 30 to 31 days?
Not at all. No, not at all. That's not my testimony. No, not at all. No.
Right.
No, and I'm not saying that, again, I'm not saying that stipulated agreements with small employers are all done under duress. Not at all. I'm just saying that, the board needs to be careful in, I think, accelerating and taking into consideration kind of the disadvantages that small employers have when they don't have in-house expertise.
Okay.
Ms. Milito, part of the focus of the Act is not just on having elections, but it's to produce stable bargaining relationships that benefit all sides if a majority of employees support union representation. Just because your organization is associated with small businesses, what's the level of familiarity that most small businesses have, if they're presently non-union, with the rules that govern how bargaining takes place if a union prevails in an election, and how much time do you think is needed for people to become familiar with those rules?
I mean, I think their familiarity with labor issues and with employment issues in general is small. I mean, they don't know much. They opened a restaurant, they opened a small manufacturing plant, not because they knew anything about union or employment matters. So there is a steep learning curve, and again, that's why they're dependent on finding, outside help. But I do think it depends. I mean, I certainly have, some members who are better educated on this just because of the industry they're in. So I think, there's some variation, but by and large, most don't know much about labor or employment matters in general.
Okay, thank you.
Okay, thank you, Ms. Milito.
Thank you.